So now today we are going to try and demystify the deed of conveyance. Okay, as one of the first parts of it. So the second part is the deed of conveyance. Many of you may have appeared for the exam, may have attempted the exam, or may have done conveyancing practice in your articles, may have found it difficult to understand the companies. That's why I have circulated two drafts. So we will do it as an interactive between the PPT, which gives the broad framework, and the draft. We go side by side. So let us start with, and I will try and explain to you as to how you should study a conveyance, because covenants come regularly in your papers, and it is very, let's say, like very difficult if you just try and mug up a whole covenant. You're supposed to know the contents of the covenant. For that you will get your full 10 marks or 5 marks or 20 marks or whatever that is. But to learn the covenant in one shot is, for me, it was an impossibility. It had to be broken up in multiple layers. So as we go along, I will deal with that. Rashna, our secretary. Okay, so let's start with what Section 54 of the Transfer of Property Act says. It defines the sale as a transfer of ownership in exchange for a price paid or promised, or part paid and part promised. Okay, so ingredients are, it's a transfer of ownership. It is in exchange for a price, which is either paid or promised, or part paid and part promised. Section 54 further says as to when a sale and how a sale is made. So if it's of tangible immovable property of the value of rupees 100 and upwards, it is by a registered instrument. This you will find in section 17 of the Registration Act also. If it's a reversion or other intangible thing, it's also by a registered instrument. Then if it's of tangible movable property of value less than 100, you can either do a registered instrument or you can just do delivery of property. The option is yours. Now, therefore, what are the essential ingredients of a sale deed? The essential ingredients of a sale deed are the place. So, it will start by saying this indenture made at so and so. So, if you look at the sale deed that you have with you, it says this indenture made at blank, this blank, day of blank. So, the first two ingredients are satisfied, the place and the date. Then comes the parties. So normally a sale deed will have a vendor, a purchaser and a confirming party in occasion. If there is somebody, as yesterday's lecture Conveyance mentioned, the confirming party is not in all transactions. It may be where some right has been created in favor of somebody, like there was an agreement for sale. The agreement for sale, the purchaser doesn't want to go forward with it, and therefore identifies another party to buy his rights, and the vendor is willing to sell it to that person. Then in that case, there will be a confirming party who will confirm the transaction. Or it could be a beneficiary of when there is an inheritance. So that could be a confirming party. So now what is important is that a vendor could be an individual, a vendor could be a company, it could be a private limited, public limited, partnership firm, LLP. The expression clause which you will see in the indenture of sale document, what is provided over here for the vendor is only for an individual. So it therefore says expression clause is which expression. Firstly, you have to define. Please understand, we will read this together. The vendors say ABC. You have to either put his PAN number. Now it's essential to put PAN numbers in the document. So either you put it as a part in the beginning, or you put it as a separate clause at the end, say the PAN numbers of the vendors are so and so, PAN number of the purchaser are so and so. However, if you put the PAN number here, let me say that this is just a draft. This is capable of being added to and everything. So you should not take this as the final thing on which you will get 100 marks. Okay? So this is just a guideline. So the PAN number comes, then you say of whatever inhabitant, Mumbai, India inhabitant, or if he's a foreigner, then you have to say foreign citizen. I'm telling you this because tax has to be deducted at source under the Income Tax Act. I'll come to it later. It is different for an Indian resident who is a vendor, and it's different for a foreign resident or a foreign citizen, even if he is an NRI. The tax structure is different. There are different sections of the Tax Act which apply. So therefore, it is essential to identify whether he is an Indian or he is a foreigner. So and so inhabitant residing at his address, and hereinafter call the vendor or vendors. Now, let me also tell you that when you have one vendor, the expressions that you use going forward, the vendor doth hereby, the word doth is used. When it's when there are two vendors, you will say vendors do, and each of them doth. So these are small things which you should try and remember. You will see it in the body of the document, but these are things that you should remember because this is what makes the difference between getting that extra half mark, extra 1 mark. If the examiner sees that you have actually understood the essentials, because this is old English drafting, but it is very, very clear if you break it up. So the expression clause says which expression shall, unless it be repugnant to the context or meaning thereof, be deemed to mean and include his or their. There I put just because there are two vendors, respective heirs, executors and administrators. In vendor, never put assignments unless the vendor is retaining to himself some rights to further assign. So in a normal conveyance, when a vendor sells property, there is never to be, I find very often, even today, drafts which one gets from other, today brokers also do drafting. They will write assignments without realizing the vendor, once he sold all his rights, has no rights left. So there is no question of providing for an assignment. So the word assigns only means that you can further assign. So the word assigns must never come in the expression clause of vendors. Then for the purchaser, the same thing. You will put the name, the PAN number, his residence, his expression clause. Now in that you will see that the word assigns will get added. Now there is a difference. If, for example, a client comes to you and says that I want to buy this flat, the first question you will ask is, are you buying it in your sole name or are you buying it in 2 or 3 names? Suppose he tells you that no, me and my wife are buying. What would be the question you will ask about ownership? How are you going to hold ownership?
Proportion?
Yes, proportion. What else? Yeah.
As joint tenants or
Yes. Yes. What is a joint venture?
survival or survival.
Okay. And what is a tenants in common?
Each has an equal share.
Is it necessarily an equal share?
Not necessarily, but whatever proportion there, their legal heirs will inherit upon their death, whereas if it is survivor or survivor, the last survivor of the only their legal heirs will inherit.
Correct. So therefore the difference is exactly what she said. A joint tenant, if two people are holding a flat or bought a flat together, on the death of one, the second person will inherit automatically. A will not override such an agreement. The law of succession will not override such an agreement. This you will find if you look at the Transfer of Property Act, if you look at Mullah and the commentary in the subject index at the back, you look at joint tenancy, you will get this. Joint tenancy doesn't mean that it's a tenancy. It's just an expression of joint tenancy. Whereas co-ownership is you hold in whatever proportion you want. Suppose the husband has invested and he wants to hold 80%. He can hold 80%. The document can have a clause which will say that Mr. X holds 80% and Mrs. X holds 20%. It will then their proportion. They can will to whoever they want in whatever fashion. So Mr. X would be free to will it to a stranger. So normally if a family is buying, you would possibly recommend that because it's a family, you want the property remaining, especially if it's residential, you want the property remaining within the family. You don't want Mr. X tomorrow to kind of try and throw his wife out. Assuming of course that he continues to be married. If he does not continue to be married, then you have a problem because then if she's a joint tenant, she will anyway get it. So these are things that you must think of, you must ask, and you must therefore change your expression clause accordingly. Very often, especially you see the development, what agreement the developers do. They don't even, they just generally have heirs executors administrator, that the respective heirs executors administrator. They don't even have an option. So if you are buying from a developer, or your client is buying from a developer, you must raise the question and you must put the expression clause clearly. And further you must then amplify it in the agreement by adding a clause if you can. If the developer, for example, will say this is a format document, I will not allow you to make even a small change, but you will agree to joint tenancy provided you understand what it is. So therefore, please see the next part, that at the bottom of the page, which is for joint tenants. Deemed to mean and include the survivor or survivors of death and the heirs, executors and administrators of the last survivor, is or their assigns. Okay? Then we go on to the confirming party is not provided. It is the confirming party is described now. Now yesterday Conveyance explained to you the expression clause changes. If it's a company, it becomes successors and assigns. If it is a partnership, it will become partner or partners for the time being of the said firm. If it is an HUF, it may be karta or the co-partners. So your expression clause, depending on what question you are asked, you must take care of the fact that the expression clause has to be modified. If somebody says the vendor is a company, you cannot say as executor and administrator. Please be careful when you do these things. Now let's go ahead to what is the recitals. So what is the word which we use to identify recitals in a deed? If I say this is the recital of a document, what is the first word which you use? Whereas. Okay. So now tell me what is the first recital, if you see the PPT. What is the first recital of cease and desist? Don't look at the draft. I want you to tell me what you understand. Why don't you guys come forward, whatever places there are. What is of cease and desist? Cease. Go on. is to say that the vendor is seized and possessed of. So when you said seized, that is completely right. You have to say seized and possessed of and sold and absolutely entitled to. So that is his first explanation or recital, saying that this is the title. So now let's look at the recital A. The vendor is absolutely seized and possessed of, or otherwise well and sufficiently entitled to. Now these are important words. Okay? You have to remember the highlighted words. Now then you are describing the land. So to the piece or parcel of land, and this is a conveyance of land or ground. If it's a flat, you will say differently. There you will say differently. You will say shares, you will say the incidental benefits to the flat, the security deposits, all that. And then you will put the description, situated so and so, along with if there are structures, if the land normally goes along with structures and all that. So if you are, for example, selling a bungalow or doing a deed of conveyance for a bungalow, then you have to describe what that is, because every time you are not going to be repeating, saying the land situate at so and so along with structure. So define it. Either define it as property, premises, whatever is comfortable, or flat, or even in a flat sale agreement, we write premises sometimes, which we say the shares, the flat, and also the incidental benefits are all together collectively referred to as premises. So depending on that, you define it. And then more particularly describing the schedule. Later on in the operative part, you will find that there is a plan also, and there is a demarcation. Then the next recital is the agreement to sell. So if there is a prior agreement, suppose you have done an agreement to sell, then you will recite that there is an agreement to sell, that you have received some earnest money or received part consideration, whatever. If there is no agreement to sell and it is a direct conveyance, like all money is being paid up front, there is nothing prior and point of time in writing, there is no requirement for this recital at all. And this will say whether you are selling free of encumbrance or you are selling on as is where is basis. As is where is basis is, suppose you have some encumbrance, you have a slum on the property. You have somebody who has filed a suit against you. You will not give a title free of encumbrance. Then you will say as is where is. For title, you will say as is what is to the condition of the property. So, and then this, if there is an agreement to sale, it will record, the recital will record if earnest money has been paid. So there are these three ingredients which normally come in an agreement. Now we go to the, what is the now this indenture witness, which is called the testator. If an examiner asks you what a testator means, then the testator means now this indenture witness is hereby agreed by and between the parties as follows. That is what the testator is, and then below that the ingredients in the testator now. Let's first look at the PPT. The consideration and receipt clause. It will record if earnest is paid. It will record if there is what is the balance consideration, there is no earnest and everything is being paid on or before execution. It will record the TDS payment, which has to be deducted. The moment some payment is made to a vendor, TDS is deductible immediately on or before payment. Okay? It is section 194RA of the Income Tax Act if it is a residential. When is TDS not deductible under 194RA? Anybody?
If a span of 2 or 3 years again invest.
When the consideration is less than 50 lakhs.
Yes, one more. Less than 50 lakhs for all properties, you are right. There is one more. If it's agricultural property. So then there is no TDS deductible upfront. Otherwise, even at the time of payment of earnest, you are supposed to deduct it. If it is a foreigner who is a vendor or a foreign citizen or a non-resident Indian, so long as he does not have an Indian resident status, 195 of the Income Tax Act provides for deduction at a much higher rate. It falls in, you have to deduct, it's the obligation of the purchaser to deduct. However, if the foreigner has no other income deducted at 20 plus surcharge, 23%, 24%. So, whereas in the case of 194IA, it will be deducted at 1% of consideration. In the case of 195, it will be deducted almost at 23 plus, 23, 24 plus. Now, where is a foreign citizen? He has the option of applying to the assessing officer for a lower tax deduction. That takes a long time. But if the foreigner, so today very often chartered accountants of non-residents advise them, no, let the tax be deducted, we will get the refund. It's faster to get a refund than to go through the process of getting a lower tax deduction certificate. However, if the vendor gets a lower tax deduction certificate, the tax deduction certificate will say what is the percentage on which consideration has to be deducted. So if he says it has to be deducted at 8%, then you will deduct it only at that much. Then the purchaser is fully relieved of his obligation to deduct at the higher rate. If that assessing officer has given the certificate, he will deduct it at the rate prescribed. That is a deduction under 197 because the assessing officer gives the certificate. So therefore, these three ingredients have to be taken care of. Now, let's read this now, this individual witnesses from the document. In pursuant to the agreement in consideration of the sum of rupees so and so, paid on blank as earnest money. All this would change depending on the facts of your case. Nothing, no drafting is copy paste. Okay, this is one thing which I'm sorry to say this, but I find that the present generation, because it uses computer, it is very easy to copy paste from a previous procedure and apply it and then not read it. Every agreement, whether it's a conveyancing matter, litigation matter, it's not a copy paste. Please read it. It is what I always tell my juniors. One thing that clients pick up, they may not know the law, but one thing that they do pick up is spelling mistakes and grammatical errors. And it gives a very bad impression. It shows basically that you are not diligent enough, you do not care enough to see that you give a perfect draft. So as far as possible, please, even if you are doing copy paste, and I know that it is easy, that when there is a precedent, even I do it. But take the time to read the whole document and correct all the corrections. Like sometimes one finds a vendor as a he and you are copying it for a she, but that he and she does not change. It's as simple as that. I'll give you a story. I have a client. His English is fabulous. He would look at my drafts, not that he knows the law, he would look at my drafts. The day he would find a mistake, he would phone me up and say, "Yeah, I found a mistake." And the day he would not find, he would feel very sad that he's not managed to find a single mistake. So try and see that your clients do not find any mistakes. Ultimately, the aim of the exam is to become solicitor, will practice, and you must give the best to your clients. So let's go on. As earnest money is aforesaid, and of the further sum of rupees so and so paid by the purchaser to the vendor on or before the execution of these presents, and of the further sum of rupees blank paid as TDS. You could always divide it into sub-parents. So today people tend to, the old conveyances were all as one long sentence. Now people tend to, especially when they do deeds of transfer, flats and all, they tend to make para numbers, which also is fun. The conveyance in the typical form is one straight paragraph. So TDS, you specify which section is being deducted, making together the aggregate consideration. Because then you have to say what is the aggregate consideration, which your stamp duty will be paid. If it's higher than the ready reckoner value, you will pay it on the basis of the document. If it's lower than the ready reckoner value, then you will pay it on the ready reckoner value. So making the aggregate consideration of so and so. And then see, now this portion below that, the bracketed portion, is the receipt clause. It says the payment and receipt whereof the vendor doth. So now please see the word. If the vendor is doth, or the vendors do, and each of them doth hereby admit and acknowledge, and often from the same and every part thereof, do forever, which release and discharge the purchaser. He the vendor doth do, and each of them. So we have finished this. So the receipt clause ends the discharge the purchaser forever. Okay? Now, so you can close the brackets at forever. means I discharge the purchases. Now you come to, let's look at the PPT. You come to what is called the operative words. Now, what are the operative words? The operative words for a conveyance are different from those of a lease. When you have your lease lecture, the person talking to you will explain the differences. So, the operative words for conveyance are grant, sell, assign, release, convey, and assure. These are words that you must know and you must write them. In a lease, the word demise will come, the word sell will not come. Demise does not mean somebody has died, it means a demise of a property. So grant, sell, assign, release, convey, and assure. And therefore it says, he the vendor doth, and do each of them doth hereby grant, sell, assign, release, convey, and assure. Unto whom? Unto the purchaser. And for what period of time? Forever. Because this is the deed of conveyance. And you are transferring complete title. So it is forever. Then you have to describe the property. So that is known as parcels. So if you look at the PPT, you will then find the next thing that you have to address in a conveyance is parcels, which is description of property. Then if you have a plan, then you demarcate on the plan. And therefore, let's read from the draft. All had the piece or parcel of land or ground with the messuages, heritages, and premises. This is because of the Transfer Property Act, which says that immovable property goes along with all this. Situate at so and so, and then you give the full description. Along with structures standing thereon, and more particularly described in the schedule hereunder, and delineated on the plan, and thereon surrounded by red color boundary line. So it's always better to put some boundary line. If there is some right of way, then you demarcate the right of way in a different color. You demarcate your reservation in a different color. If you are retaining some portion, you may have multiple permutations, combinations. So accordingly, you keep it up. And then collectively referred to as the premises. So again, the same thing that you have mentioned in the recital gets copied here within slightly greater detail in the operative part of the conveyance. This entire thing, this testator is entirely the operative part of the conveyance. And it is what will actually transfer title. And it again gets repeated in the schedule of the property. You should put at the end. Then you come to general words. The general words I have broadly divided them. If you look at the PPT, houses. Under houses you will find houses, outhouses, edifices, buildings, courtyards, areas. Okay? So if you try and divide and learn them bit by bit, if you remember the first 5-6 ingredients and you then divide and learn it bit by bit, you will find that it all comes automatically. Everything in the conveyance cannot be learned in a day. It has to be learned over multiple days and multiple revisions. So like if you have, for example, studied the first part, you learn the operative words. When you are doing the parcels, repeat the operative words so it's like refreshing. Read it again. The more times you read it, the more times you write it, the more times you hear it. Record it on a tape. Hear it when you are just sitting idle or you're tired. Just it playing in the background is what will seep into your mind. Okay? Then comes the next part, which is compounds, sewers. Along with sewers comes drains, ditches, fences. Then you get trees. Trees has plants also along with it. Then you have ways, paths, passages, common gullies, easements, profits, advantages, rights, members, and appurtenances, whatsoever. So everything gets covered. You can make your own, of course, key to learn this. This may not be a perfect key. I am myself finding that some things are like waters is there and then lights, liberty is not separately mentioned. So divide it, put it so that you know that now I have to talk about, first I have to talk about houses and compounds, then I have to talk about trees, then I have to talk about raised parts, then I have to talk about water, then I have to talk about easement rights. So whatever is there, if you are conveying all this, if it's a a general normal conveyance, then please add all this. Then we come to the deeds and benefits of the covenant of production. So deeds you are always giving. The vendor is obliged to hand over the deeds. However, in some cases, suppose it's a large piece of our 5-acre land. You may be selling only 1 acre. You may be retaining to yourself, because they are common title documents, you may be retaining to yourself the 4 acres. Then you are entitled as the larger landholder to hold all the original documents. So then you will give a covenant for the production of title. So this is just the operative word, and also together with all these documents, writing, vouchers and other evidences of title relating to the said piece or parcel of land and premises or any part thereof, and also together with the benefit of the covenant of production of title deeds contained in the indenture of conveyance dated so and so. Now let me explain this a bit. This says covenant for production of title deeds contained in the indenture of conveyance. So there could be a situation where there is a large land. You have purchased, you are the vendor. You have say purchased out of the 5 acres, your vendor has sold to you say 3 acres. He has retained 2 acres. Now out of the, so he has, no sorry, let me give you the reverse. Your vendor, your predecessor in title, has out of the 5 acres sold to you 2 acres and he has retained 3 acres. Your deed of conveyance has a clause saying that he will produce for you the title deeds whenever you call upon him to do and whenever you require at your cost. That when you from those 2 acres sell 1 acre, you don't have the title deeds to hand over. You have to pass on the covenant for production. So therefore, it has to say along with the covenant for production contained in the deed of conveyance dated so and so. So that your purchaser is able to identify who he has to follow to get the deeds. Because he can't call upon you, he can call upon your predecessor in title, saying that look, I have this covenant, please now produce these documents. So let us just see section 55(1)(3). Lots of the conveyance, and I've tried to correlate some of the clauses with the Transfer of Property Act. So section 55(1)(3) says the seller is bound, okay, and okay, where the whole of the purchase money will be paid to the seller, he is also bound to deliver to the buyer all documents of title relating to the property which are in the seller's possession or power, provided that where the seller retains any part of the property comprised in such documents, he is entitled to retain them all. Where the whole or such property is sold to different buyers, the buyer of the lot of greatest value is entitled to such documents. But in case A, the seller, and in case B, the buyer, of the lot of greatest value is bound upon every reasonable request by the buyer or by any of the other buyers, as the case may be, and at the cost of the person making the request to produce the said documents and furnish 2 copies thereof or extracts therefrom as he may require. And in the meantime, the seller or the buyer of the lot of greatest value, as the case may be, shall keep the said documents safe, uncancelled, undefaced, unless prevented from so doing by fire or other inevitable accident. The words of 55(3) proviso is what you will find in the covenant for production of title. So everything that was drafted in the olden days is in line with the Transfer of Property Act. It is a statutory obligation on every vendor to hand over title deeds or to give a covenant for production. Then you come to what is called the All Estate Clause. Does anybody know what the All Estate Clause is? Anybody? Okay. So the All Estate Clause basically says, if you look at the document, and all the estate right, title, interest, use, inheritance, property, possession, benefit, claim and demand whatsoever, at law or equity of the vendor, into, out of, or upon the premises or any part thereof. So whatever the vendor has, he is giving by this document. So everything, all his right, title, and interest. Then very often you get a question saying, what is the habit? What is the habit? What is the habit? What does that mean?
You are giving the right of possession to the property to the person.
Okay, that's right. So now let's look at the habit. To have and to hold, all in singular. So what are you giving to have and to hold? You are giving possession because you are under the Transfer of Property Act required to deliver possession at the time of a sale. So to have and to hold, all in singular, the premises hereby granted, released, conveyed and assured and intended and expressed to be. So if you compare these words granted, released, conveyed and assured, you will find the same repetition in the operative words. It says grant, release, convey and assure. So the same kind of words come and intended or expressed to all these. With their every of their rights, members and appurtenances, you will find repetitions of words. You understand what I am trying to say. Earlier these same kind of words have appeared. So you will find connection. You learn the first part, you find the second part easier. Unto and to the use and benefit of who? The purchaser. Forever. Because it's a conveyance. As what? Now here it is better that you specify whether as tenants in common, in equal shares. Of course you can say tenants in common in the proportion mentioned here and after. So you could specify that it's 60% and 40% or whatever. Or the other option is or as joint tenants. So that on the death of one, the survivor or survivor should be entitled to the whole of the premises absolutely. So you find a repetition of words and each of them expands on the concept. This is a full transfer. Then, so therefore now in the PPT I have specified that you in the habitual when you say to have and to hold forever, which is the operative word, you will also specify whether it's tenants in common, joint tenants, etc. Then you get exceptions and reservations where there are payment of taxes, there are rents, etc. etc. Now for that, let's look at 55(1)(g) and 55(5)(d). Okay, so the Transfer of Property Act says the seller is bound. And it's just a suggestion, we had put it on the notice that when you go for these lectures, you carry the principal acts which are subject matter of the lecture. It would assist you in understanding better. The seller is bound, it is 55(1)(g) to pay all public charges and rent accrued due in respect of the property up to the date of the sale, the interest on all encumbrances on such property due on such date, and except where the property is sold subject to encumbrances, to discharge all encumbrances of the property then existing. Then this is the seller's obligation. Now 55(5)(b) is the obligation of the buyer. The buyer is bound where the ownership of the property has passed to the buyer as between himself and the seller to pay all public charges and rent which may become payable in respect of the property. The principal money is due on any encumbrance subject to which the property is sold and the interest thereon accruing afterwards. So basically a normal conveyance will say that the vendor will pay everything up to the date of conveyance. Thereafter, the obligation is fully of the buyer. So therefore, we have exceptions and reservation clause in the document, which says, subject to the payment of all rents, rates, taxes, assessments, dues and duties, now chargeable upon the same or hereafter to become paid, which is the Government of Maharashtra, this all could get modified, or the BMC or public body authority in respect thereof. Now, if there is a right of pay being granted, Then there is, it's not in the PPT. You will put in there, say, as the next clause, and together fully right, liberty, and license unto and to the use of the purchaser, his heirs, executors, and administrators, his servants, agents, visitors, and tenants, by day or by, from time to time. Now these are required words in the right of way. From time to time and all times hereafter, by day or by night, for the use and enjoyment of the premises hereby granted and conveyed, or expressed or intended so to go, return, pass and repass. It has to be not only one way, you have to be able to come back. So go, return, pass and repass, before without horses. Now there are no horses, but in those days it was without horses, cattle or other animals, carts, wagons or carriages, laden or unladen, by foot or by vehicle, in, along, through, over and upon that strip of land or road, indicated and demarcated for the said purpose, or planned by red dotted lines, to hold the premises hereby granted and conveyed, or expressed or intended so to be. Okay, so this is the covenant that a vendor would give to a purchaser if the purchaser has to be given a right of way. Suppose the purchaser's property which he is buying is not road facing, it is inside, and the vendor has retained with him road facing property. He has to give her access, and therefore this is a right of way which a vendor gives to a purchaser. The other one is, the one below, is the right of way which the vendor retains for himself. So accepting and reserving, the wordings change. Accepting and reserving unto and use for the vendor, his heirs, executors, and then the rest of the covenant is the same. So the first part is along with full free right, liberty and license to access, and the other one is accepting and reserving. He is reserving to himself. So the rest of the covenant is the same, but the operate beginning change. Now these are part of reservations. So if there is no right of way, these two covenants do not come in at all. Now you come to the basic covenants. Can somebody tell me what are the basic covenants if the property is being sold free of all encumbrances, full title deed? No. Tell me what are the covenants. Just give me the names of those covenants. Lovely. Enjoyment includes further assurance. So let's say, what is the covenant for title? What does a covenant for title? What does it mean to you? What does the covenant for title mean? What do the words mean? When you say you're giving a covenant for title, what are you trying to do? Yeah.
All the sick bundle of rights along with the title to the covenant for title. So the vendor is giving a covenant to the purchaser that okay, along with the title, we are giving you the title. Along with it, we are also going to make sure we are giving a covenant for possession, for
those are all different now. The covenant for title is what?
Indemnity, but it has title to part.
It is not an indemnity in that sense. It is a covenant which says that look, I am the owner and I am representing to you that I am the absolute owner of this property. That is what a covenant of title is. There are other covenants. So if you look at the PPT, you will find there is a covenant for title, there is a covenant for quiet enjoyment, which is what you were saying, possession and things like that. That is covered in the covenant for quiet. Then free from encumbrances, that means there are no encumbrances on the property. And further assurances is that if you come to me and say that I need to mutate this land and I need you to sign an affidavit confirming that you have signed, you will do it for me. It's an assurance that I will do whatever reasonable acts are required even after deed of conveyance to see that you get full title. That is what a further assurance is. So now let's read 55.2. 55.2 says, the seller shall be deemed to contract with the buyer that the interest which the seller professes to transfer to the buyer subsists, that he has a title and that he has power to transfer the sale. Provided that where the sale is made by a person in a fiduciary character, he shall be deemed to contract with the buyer that the seller has done no act whereby the property is encumbered or whereby it is hindered from transfer. This is the limited covenant of title which I come to, which a trustee gives. The proviso only talks about a limited covenant, because a trustee is not a trustee for life. There may be a charitable trust, there may be trustees changing from time to time. He is not bound by acts of the previous trustees, but he has to say that he has title. He has not done anything which is without title. The benefit of the contract mentioned in this rule shall be annexed to and shall go with the interest of the transferee as such, and will be enforced by every person in whom that interest is for the whole or any part thereof from time to time vested. Now let us therefore now read the covenant for title. And the vendor doth hereby for himself is as executive administrator, which is in every covenant you find. Covenant with the whom, with the purchaser, that notwithstanding any act be, the word is notwithstanding, because he's giving a full covenant. This will not come in a limited covenant. Notwithstanding any act, be, matter or thing whatsoever, by the vendor or vendors, or by any person or person, lawfully and equitably claiming by, from, through, under or in trust. So anybody, not only the vendor, he said nobody claiming under me, none of, not my heir, nobody or not my predecessor, nobody can raise any issue with regard to my title. I am giving you full title. Done, committed. So what is he saying? That notwithstanding any act, being, matter or thing, by the vendor or any person or persons lawfully or equitably claiming by, from, through, under and trust for him, done, committed, omitted, or knowingly or willingly suffered to the contrary, he, the vendor, now has himself good right, full power, and absolute authority. So that is the representation that there is no encumbrance. I have full power and absolute authority to do what? To grant, release, convey, or assure the premises hereby granted, released, conveyed, and assured, or intended so to be, unto and to the use of the purchaser in manner or form. Again, there is a repetition of the same words. Now you come to the next one, which is the covenant for quiet enjoyment, and for that you see 55.1f. It says to give on being so required. This is the obligation of the seller. To give on being so required the buyer or such person as he directs such possession of the property as its nature admits. So let's read the covenant for quiet enjoyment. This is the question of handing over possession. And that it shall be lawful for the purchaser from time to time and at all times hereafter, peaceably and quietly, to hold, enter upon, have, occupy, possess and enjoy the premises hereby granted to the applicants and receive. So if there are tenants, to receive the rents, issues, profits and every part thereof for his or her own use, benefit, without any suit, lawful eviction, interruption, claim or demand. So nobody can file a suit against you. That's a representation to the vendor. Then even if there's a suit, you are still entitled to free enjoyment. Lawful eviction, interruption, claim and demand whatsoever from the vendor or by any of his heirs or any of them by personally claiming by, through, under and trust fund. So again the same words which came in the covenant of title get repeated. The moment you learn one part, you will find that repetitions keep happening and it becomes easier to learn. Then you come to the covenant free from encumbrances, which is 55.1g. Where he represents to pay all public charges, rent due, accrued in respect to the property. We already read that. We read it as a part of the rents and law. So let's read the covenant. And that free and clear, and freely and clearly, and absolutely acquitted, exonerated, released, and forever discharges and encumbrances whatsoever, either already or to be hereafter had made, executed, occasioned or suffered by the vendor or by any other person or person lawfully or equitably claiming by under the trust law. Then you come to the last of the covenants, that is the covenant for further assurance. And further, he, the vendor, and all persons having or lawfully equitably is the same thing, shall and will, from time to time and at all times hereafter, at the request and cost of the purchaser, do and execute, or cause to be done and executed, all such further and other lawful and reasonable acts. If he tells you to do an unlawful act, you are not bound. If he tells you to do an unreasonable act, you are not bound. All other lawful and reasonable acts, deeds, matters, conveyances and assurances of the law whatsoever, for the better, further, and more perfectly and absolutely granting and assuring the premises and every part thereof hereby granted unto and to the use of the purchaser and manner of person. So basically, to see that the title as promised is given fully. Now we come to, I'll just we'll go a slide ahead and come back. Covenants in a sale deed where there's a trustee or an executor. As I told you, an executor is appointed after death of the deceased. He is not aware of what the deceased has done. He cannot give a full covenant of title. He cannot give a full covenant free of encumbrance. The first four covenants cannot be given. This is what we were taught when we were studying. Today I very often find conveyance deeds which are from a trustee, and they will have the four covenants. Then you have to tell the person on the other side, look, if I am a trust, I cannot give you the four covenants. I will only give you a limited covenant. And it's a restricted covenant. It governs only the acts of the trustee or the executor at that point in time. So let us read the restricted covenant. So please make a note that the first four covenants do not count. So if you are asked to do a conveyance of where the vendor is a trustee or an executor, you will only give the limited covenant of that. And the vendor dot and do each of them dot so far as relates to his acts, only his acts, and not further. Dot hereby, covenant with the purchaser that the vendor has not done, omitted, or knowingly or willingly suffered, or been party or privy to any act, deed, or thing, whereby he is prevented from granting and conveying the premises in manner aforesaid, or whereby the same or any part thereof are, is, can, or may be charged, encumbered, or prejudicially affected in estate, title, or otherwise howsoever. So he says, I am only bound to the extent of my acts. Of course, then your other side solicitor may say, no, but give me further assurances and give me quiet enjoyment, etc. Then you could possibly put it in some fashion. It's a matter of negotiating. Though strictly, you are not required to give anything other than this one. Then we come to the covenant for production of title deeds and the substituted covenant. I have already read the section 55.3 proviso to you. So let us read the covenant. And the vendor dot so as to bind himself and his heirs, executors, administrators, and assignments. Now, why is he saying assignments? Earlier I told you vendors do not have assignments. Can you tell me why we are saying assigns out here in this covenant? Yes, what do you mean? Just expand on it.
He may be able to transfer it.
He will be able to transfer what? This is the vendor giving a covenant to the purchaser, saying that my assigns are also bound. Why is he saying assign?
He may have given some means or something like that.
No. He is saying assign because he is retaining the title deeds. Because he is retaining the title deeds, suppose he sells further. Then he has to ensure that his purchaser, suppose he sells the rest of whatever he is holding the balance 2 acres. He sells it off to Mr. Y. He has to see that in that conveyance, he puts in a covenant saying that there is an earlier covenant of production and you are bound by that earlier covenant of production, and then the purchaser also gets, that second purchaser also is bound to the earlier purchaser. So therefore he says assigns. And if you follow strict conveyancing practice, then you would do a separate document between that purchaser and the previous purchasers, where that purchaser will, by a registered instrument, agree that I will produce the tax deeds whenever possible. So, and the vendor got...
Sorry to interrupt you.
Sorry.
I just wanted to ask you one something.
Sure.
You have not used the word transfer in this document. You've used grant, sale, convey.
Those are the operative words.
But you have not used the word transfer. Whether transfer and convey come out the same.
Yes.
Sale.
Convey means yes. And the vendor doth so as to bind himself and his heirs, executors, administrators, and assigns, respectively covenant with the purchaser, that the vendor, his heirs, executors, administrators, and assigns, will at all times hereafter, unless prevented by fire, this you will find in the proviso, or other inevitable accident, upon every reasonable request. For example, if there is a force majeure situation and the deeds get destroyed, there is an earthquake, there is a fire, like the wildfires which happened in Los Angeles. Everything got destroyed, and you are not bound by the covenant. There is no way that you will produce. Upon every reasonable request, and at the cost of the purchaser. It has to be at the cost of the purchaser. Vendor can't be incurring cost. At the cost of the purchaser or his successors entitled. So if the purchaser has onward sold, then his successors entitled. Or any of them produce or cause to be produced to them or their solicitors or agents, or such other person as they shall direct, or in the course of any judicial or other proceeding, or otherwise as occasion shall require, all or any of the deeds and writings mentioned in the schedule. So you will put out that deeds which you are retaining in a schedule, specifically stating whether they are originals, whether they are photocopies, whether they are certified copies. Sometimes the vendor may not have originals, he may have lost, but he may have procured a certified copy from the sub-registrar's office. So it will be specified. If you don't specify, it is assumed that it's all original. And when you are called upon to produce, then you produce a certified copy, the fellow will say you are in breach of the deed of conveyance. So the schedule B must specify. For the proof, defense and support, why is this production required? For the proof, defense and support of the title and possession of the purchaser, his successors in title will permit the same to be examined, inspected or given in evidence, and will also, at the like request and cost of the purchaser, his successor, make and furnish, or cause to be made and furnished to them, such true, attested or other copies or extracts or extracts from the same deeds and writings as they may require. So he may call upon you, I want a certified copy, I need to produce it in court, I need to somebody's file a suit against me, challenging my title, etc. So all these, if you break it up, you will find that there are different parts to the covenant. The covenant provides firstly that you will preserve the documents, you take care of it, except if there is some fire, inevitable accident, then you will cause to be produced. Where will you cause to be produced? For the proof of and defense of title, you may produce it in a court, you will do it at his cost, you will have to give him copies if he asks and pays for it. Now there is what is called the substituted covenant. So you must distinguish between the two. There is a covenant of production and there is a substituted covenant of production. You may be asked by examiner only a covenant of production of title deeds. If you have time, you can write the substituted covenant. But it is necessary to write the substituted covenant only if the substituted covenant is asked. Provided always, and it's hereby declared that in case the said deeds and writings herein are covenanted to be produced to any of them, shall or may any time hereafter be delivered by the holder or holders thereof to any person or persons lawfully entitled to custody thereof, and such person or persons shall thereupon enter into with and deliver to the person or persons for the time being entitled to the benefit of the covenant of production herein incorporated. So therefore this says that you will deliver to whoever is in custody and thereafter. So if you are asked for a substituted covenant, possibly you have to write the covenant of production and the substituted covenant. If you are not asked for a substituted covenant, you could end at giving the first covenant of production. Now, what is the testimony? If you ask what is the testimony, what is the testimony? Yes. Are there some words which identify that this is the testimony? No. So it says in witness whereof. So when you say in witness whereof, that is what is called the testimonial. The vendor had set and subscribed their handles. Seal is no longer there. In once there was a Navy officer who came to my old office. I was a very article clerk, and he had to notarize something, and then he signed, and then he took his ring and put a seal. So his ring had the seal. So in the olden days, all individuals also had seals. That's why the old English drafts say sign and seal. But just now write only sign. So hand, respective hand, the day and year, first hearing about it. Then you come to what is the schedule. So the schedule now has to be detailed. You may not have such great details in the recital. You may have more details in the testative part, but in the schedule you must have full details. So the details not only cover where the land is situated, which CS number, as Conveyance yesterday said, CS number in Bombay City, CTS number in the suburban. Then you have gut number, Hissa number, all that, where there's agricultural land. Depending on that, you must write proper descriptions, proper areas, because otherwise if you write wrong areas, it can become an issue, especially if you're dealing with land. Then you would have to do a deed of rectification to clarify that area, that there's a mistake. And you must, if there's land especially, you must give boundaries. So on or toward the east by land bearing survey number so and so, on or toward the west by road name so and so, or whatever. Give the boundaries so that the land can be identified. And then you come to execution and attestation. Now let's see how much, I don't know how many of you attended yesterday's lecture, which are the documents of which attestation is compulsory requirement. Yes. Yes. Excellent. I think I should tell Tanvi, you guys are very good. So the execution clause says sign, seal and deliver. You can remove the seal, sign and deliver will also do. And we normally say in the presence of, as she said, it is not compulsory, it is a matter of practice. If there is any dispute, the witness can come to court. Then the last thing which comes is the receipt clause. Okay? This is the receipt which you will give for all the money that you receive under the contract. So you could put it as subparagraphs. You could say receipt the day here, first hearing about written, often from the within name purchase. Who have you received it from? You must say. He may pay you by pay order, but you don't know whether it's come from this. Today with the PMLA Act, you have to be careful to see that there is not proceeds of crime which come. I'll give you an example. We had a matter where my clients were a charitable trust. They had received some earnest money, and after they received it, they received a notice from the enforcement directorate. There was a charity commission order for sale, etc. The balance was payable over a period of time. The first earnest which was received, he found out, he sent a letter to the trust saying, deposit the money with us, this is proceeds of crime. Received from XYZ, this is proceeds of crime, deposit the money. To which we replied, fortunately we were in litigation because there was a dispute going on with the purchaser and we were not paying the balance. We were in litigation, we wrote back saying that, look, this is all a subject matter of the High Court and we cannot transfer any money to you, and he didn't do anything. So therefore it is essential to try and find out source of funds. Today, if you can, in a transaction, request the purchaser. See, a purchaser may get very upset and hurt, and his ego may get hurt if you say, is this money proceeds of crime? Or give me a declaration this is not proceeds of crime. You have to handle it tactfully, somehow getting some, saying that, somewhere something, putting the document. Ultimately, if you go back and see one of the BIS lectures on the website or given by Behramkamdin in PMA, his answer to the question raised as to whether the ED can come in after you have sold off your land, come and say, they take away this, give me the money back. The land has gone already to the purchaser. You are tracing the money which he has paid. To his answer to that was that you could have as a vendor a good defense, saying that you have handed over valuable property, and it's not as if you have sold a 1 lakh property for 10 crores. It's not, you will not receive 10 crores for 1 lakh. If you have received 10 crores for a 10 crore property, you have a good defense. So you would be able to litigate successfully, but you would have to litigate because the ED is the ED. So, receive the day you heard first heard about written, often from the within name purchaser, the sum of rupees so much. You will have to say by what method, whether it's RTGS, pay order, check, etc. Because please understand that once you register this document, it will go to income tax automatically, and income tax will raise queries on the transaction if it works. It may give you a scrutiny notice saying where does this money come from, why is it there. For example, if there were originally 2 vendors, suppose you had purchased office with your spouse, but you have put all the money, and that original agreement said that it's just for the sake of convenience that this name is added. He may be a joint tenant or otherwise, but the name is as of now added for convenience. The entire money has been paid by the other person. The ED and therefore consideration on your selling has to be received only by you and not by your spouse. And that is what you will recite in your deed of conveyance. That the consideration is paid entirely to vendor number 1. ED may still issue us, income tax may still issue a scrutiny notice saying why has vendor number 2 not received any part of the consideration. So you have to be careful and see that it is all covered in your registered instrument. Otherwise, a whole hearing will start and everything will be opened up and you will have to try and justify why the vendor 2 has not received. Similarly, if only one purchaser has paid, the second purchaser has not paid. So the proportions are different. Please specify. So specify the mode of payment. If both purchasers are not paid, say within name, purchaser number 1 or whatever. Received on the blank day of blank by so and so. Also specify that money under 194 IA, 195, how much is the TDS deducted, etc. Now, with regard to the TDS, I want to add one more thing which is not in this draft. Is that quarterly returns for TDS are quarterly based. There are certain forms which you have to collect at the time of the sale or the deduction of TDS. But all these you can get the challan immediately because it's online. So the moment the purchaser pays, he will give you a challan. But the 26QB and the other forms may come only subsequently. So you must put in a clause within what time frame they should come to you. So those could be additional clauses to the conveyance. Now, if you are very tired, we can take a break and then we can continue because the second part, which is the gift deed, is shorter. We can continue with stamp duty and registration after a break. What would you guys like to do? Take a break just now? Yes? No? Okay. Let's then finish with this registration and stamp duty. So, section 17. Feeling cold. Ganesh, थोड़ा AC कम करो. Section 17 of the Registration Act requires the sale deed transferring immovable property of the value of ₹100 or upwards to be compulsory registered. As I told you earlier, the Transfer Property Act also requires it to be compulsory registered. Stamp duty for the purpose of the deed of conveyance is Article 25. Article 25 breaks it up into transfer movable and transfer immovable. What I have provided in the PPT is generally for Municipal Corporation of Bombay and not all the others. There are rates which are different if it's Lonavala, etc., etc. You have to see Article 25. If you are transferring movable property, if you are doing it by delivery of possession, then there is obviously no instrument. There has not to be an instrument. If there is an instrument, then it attracts stamp duty. So if you are doing it by an instrument, it's 3% of the market value of the property. Whereas if it's a transfer of immovable property within the limits of the municipal corporation or cantonment area, it is under Article 25 of Schedule 1, which is 5% of the market value of the property. The market value of the property is not your agreement value. It is the ready reckoner value. However, if your agreement value is higher than the ready reckoner value, you have to pay stamp duty on the basis of agreement value, otherwise on the ready reckoner. Now, Income Tax Act also says that if there is a difference, I think if I am not wrong, or 10%, the ready reckoner value is say 1,000 rupees, and you have a difference which is lower than 10%. Then the income tax will treat it as concealed income, tax the vendor, tax the purchaser for having concealed income, etc. etc. So there is a margin that you have within which you have to see that your agreement value falls. So 5% of market value is the stamp duty. In April 2021, there was a notification which was issued which reduced stamp duty if all purchasers are women by 1%, so it became 4%. However, there was a lock-in period of 15 years that you could not sell to any male. Now that lock-in period had been deleted by the order of 26 May 2020. These are things I think you should know because this would come possibly a question. Now, it's transfer of immovable property. Yeah, I'm coming to that. For transfer of immovable property through sale, gift, and usufructory mortgage in City 1, that means in Bombay, or where there are vital important urban projects, there is a metro cess, as Rashna rightly said, which is a 1% surcharge on the market value. So 5% plus 1%. 5% you can do depreciation of value, etc. Then the 1% has to be paid addition. So 6% is in the case of a sale, a gift, or a usufructory mortgage. A usufructory mortgage, it is on the amount secured because there is no market value to a usufructory mortgage. So if the loan is for say 10 crores or 10 crores, 1% is the surcharge. And this surcharge was not levied for a period of 2 years during the COVID period. So from 1st April 2020, it was not levied. It's now again enforced, and that is where it is. We will take a short break of 10 minutes, and then we can continue. Yes, sorry. If there are any questions, please, before we take the break, you can ask them.
Ma'am, this particular is for transfer of immovable property, 5% market value. This is for sale because here it is to sale, gift, useful, mortgage.
Yes.
In this, what is the transfer of?
So Article 25, which I have set out, is for the first bullet that you see, is transfer of movable property.
Yes.
Okay. The second, the middle one, is the transfer of immovable property. This is stamp duty under Article 25. Okay, which is 5% in Bombay. First, transfer conveyance. Conveyance of any property, a flat, agreement, a immovable property, a land, a bungalow, anything and everything.
Transfer, policy, sale.
It's a sale. A transfer is a sale.
Yes, then here for transfer of immovable property.
That is
to sale.
So therefore, the last part is a notification, okay, which says there is a metro cess which will be levied only on sale documents, on gift documents, and on usufructory mortgages. It is not levied on any other transfer. Okay. So wherever Article 25 applies, Article 25 deals only with conveyance. Yeah, the entire Article 25, including what is there, whether it's Lonavala property, Pune property, whatever, there are different rates. When I say 5%, it's not 5% across all Maharashtra, because we're talking about the Maharashtra stamp bank. It is different for every city And there are different cantonment areas, etc., but they specify the different rates. And I think that is part of your portion. Article 25 is possibly part of your portion. You need to know the difference. I am only telling you from the perspective of Bombay. However, the metro says is also you have to see the notification. The notification will specify which areas it applies to. Where there is a development project happening, there is a metro cess levy. So 1%. So it may be levied in 1%. No, sorry, I don't have notification. So you will have to check the notification and depend. Any other questions? Yes, please.
Since most of the covenants that
I
are
can't hear you. Could you take the mic, please?
is it better now?
Yes, you can take the mic because then you can get it.
Since most of the covenants they flow from TOPA, from law, in actual scenarios, do we see a lot of pushback or negotiations in a sale deed, or are there some positions that, for example, vendors or purchasers don't agree to as such, or is it mostly like settled?
So no, so more than the purchasers would accept the covenant. I don't see a problem because it gives them everything. It's more often a pushback from the vendor side. Because if you feel that there is a chance of somebody making a claim, you may not want to give a full covenant of title. If you feel that somebody has, you have a piece of land and you have it fenced, but somebody has cut your fence open, you may say, I'll sell it on as is, where is basis. I will not sell it on as is, what is basis. I will not give you this, I will not give you free from encumbrance, I will tell you. You will put in recitals in the body of the document saying that you have investigated title, you are satisfied with my title. Like we recently had a matter where title has flown in the family from generations. And when we were about to kind of look to sell, suddenly an application was made to the office of the Tehsildar in Palghar saying that mutate this land to my name. And a Xerox copy of a conveyance deed, which was supposedly registered, was produced. The original was not produced. And we had to go there and we had to argue. And we had to kind of satisfy the Tehsildar. That look, this guy's conveyance deed is only supposedly signed by a vendor who died like 50 years ago or 100 years ago. And suddenly out of nowhere, and I have been in continuous possession, it's a plantation land. There are mango trees and chiku trees and all that. I have my security. I have people cultivating. So, which sections of the Transfer Property Act deal with gift? Come on. It's all up there. So as 122, 123 and on. Basically 122 to 120. Let's read 122. Transfer property defines gift as the transfer of certain existing movable or immovable property made voluntarily and without consideration by one person called the donor to another called the donor and accepted by or on behalf of the donor. Okay, so there are multiple ingredients. It's a transfer of either movable or immovable property. It has to be made voluntarily. You cannot coerce your father to gift you some property. Okay? It's made without consideration. That's the basic thing of a gift. It's by one person who is called the donor, person gifting is called the donor, person receiving is called the donor, and it has to be accepted by the donor. If it's not accepted, the gift does not take effect. So if your father signs a deed in your favor, you do not accept it. It does not take effect. Section 123 makes it necessary for the gifting to be attested by at least 2 witnesses, and it is compulsory registrable because it's a transfer of property, immovable property. In Bombay, it would be about ₹100. Now, the essential ingredients for gifting, certain are common to a community, right? So therefore you have place, you have gate, you have party. Over here it will be donor and donor. PAN numbers, of course, you will again put, regardless of whether there is consideration or not. Then you come to the recital, the whereas. So you will give the property which is being gifted. Then you will describe the document. So whether you are gifting the whole flat or a percentage, whatever. If you are not gifting the whole movable property, the whole flat or whatever, you will say 50%, 40%, 30%, whatever it is. You will try and put a plan, you will try and do a demarcation so that the all becomes clear. Of course, if you are not gifting the whole 100% and you are gifting, say, 30%, let me ask you a question. Suppose your father decides to gift you a share, say a 50% share in the flat. What will be the words you will use? How will you identify that it is 50%? It's a flat, it's a residential flat. It's not capable of being divided. So what will you say?
Undivided.
Undivided share. So you will say 50% undivided share right title interest. Right? And of course if it's a flat, you will have share certificates and all that mentioned. This is, as I said, only illustrative, it's only a guide, it's not something which you should follow as a gospel. Then you will put a plan. So even if it's a 50% undivided share in a flat, you could put a plan of the whole flat. Because ultimately, which part you are supposed to use is not determined. Then you have a recital of ceases, which is, as I told you, seized and absolutely possessed of. Then you have to specify the relationship. Of course, it does not matter whether you give to a stranger also. But a gift to a stranger under the income tax act about 50,000 rupees in a year attracts tax. So you define the relationship as to whether it's a parent, whether it's a natural love and affection. This also makes a difference in determining the stamp duty rate. I'll come to that a bit later. But if it is to a spouse or it's to a child, it's 200 rupees if it's residential or agricultural property. If it is to another relative, it is 3% instead of 5%. So the donee is related to the donor, being his daughter, whatever the relationship is. The donor on account of natural love and affection he bears towards his daughter. If you use the word natural love and affection, if it is a gift to a relative, wishes to give all his right title interest to the donee absolutely, and if to provide for acceptance of the gift, donee has agreed to accept the gift by executing the present suit. The gift deed is also signed by both donor and donor. And then you have to specify the market value because stamp duty, though there is no consideration for the document, you still are required to pay stamp. So market value has to be, which is very well. And we normally put in, like if it's a flat, you will put in how many floors the building has, how many lifts, which is the year of construction, because you guys may be aware that you have depreciation which you can claim on every revenue balance, depending on how old it is. And then you have the testator clause, which then you have the testator clause, which again says gift is for natural love and affection. And then you will say there the donor without any monetary consideration. So if you look at now the deed of donor without any monetary consideration and consideration of natural love and affection, which the donor bears towards the donee, brought here by grants, conveys and assures to the donee by way of gift, all its right, title, interest in so and so, standing on, they will describe the property. Again, you will define what it is within building, society, flat. They can be multiple definitions, especially when things are long. Like when you say, for example, ABC Cooperative Housing Society Limited, you could define it as society and thereafter refer to it as society. Then all definitions have to be capitalized so that you don't put it in small. So that it becomes clear when a person reads that, oh, this is a defined term, I must see what the definition is. Then the general words come together with all its singular rights, liberties, together with deeds, the all estate clause, all this is again the same as the conveyance, the habitant, having the hold, and then the donor form itself is there, the executive administrator, covenants with the donor, and then you give the four covenants. If you are giving some limited covenant or something, you can give a limited covenant. Otherwise, you give all the four covenants, and then come to clause 3. The donor hereby accepts the gift of 100% of the share of the donor in the flat and mortgage. So if only 50% is being given or 40% is being given, title deeds are being maintained, then the production covenant will also be made. And then the last clause says, donor declares that from the date whereof donee shall be sole and absolute owner of the flat, and the donee alone shall be entitled to use and occupy on what is popularly known as ownership base. Because I've done this for a flat, I've used the word popularly known as ownership base. Yesterday, Conveyance explained to you that in a flat, you have no ownership rights in the society. It's just a concept in law, therefore you say popularly known as ownership base, basically means and from the date whereof the donor ceased to have any right, title, and interest. Now, if it is for part of the document, then you would obviously provide where the donor continues to retain so much undivided share right, title, and interest. And then the stamp duty registration you will have, saying the flat is valued with so much stamp duty, therefore, and registration has been paid for. And then you have the testimonial, and you have the schedule, and if it's not a flat in boundaries, then you have the signed waiver clause, and that is your gift. So if you have learned your conveyance, the deed is much easier. Now, the transfer of a gift deed is effected by registered instrument, as we said, attested by each student. The gift must be accepted by the donor. If it's a gift of movable property, this is either by registered instrument, in which case again you have to have it attested by two witnesses, accepted by the donor, or it's delivery by way of possession. Now the stamp duty on a gift deed is, if it is a stamp act provides, if it's a gift to a family member, being a husband, wife, brother, or sister of the donor, or any lineal ascendant or descendant of the donor. So if it is a father giving to his son or daughter, or if it is a father giving to his father, so the grandfather, ascendant or descendant of the donor. So it could be to his grandson, or it could be to his great-grandson. It will attract 3% of market value and 1% interest. But please note that it is not to the spouse of the donor. Not to the spouse of the donor is covered, but not to, say for example, give to a family member being the spouse of the brother of the donor. The spouse is not 3%, not full 5%. However, if it's a gift of residential and agricultural property in Mumbai to a husband, wife, son, daughter, grandson, or wife of the deceased son, then it is 200. But the requirement is that it has to be a residential property and it has to be or an agricultural property. If it is neither, then it has to be 3%, otherwise you will get away with 200. But the 1% metro cess is still active. And give to any other not covered by either A or B is 5%. So you give it to a stranger, or you give it to a relative who is an aunt, an uncle, etc., where there is no ascendant, descendant that you can show, then it will be 5% plus 1% interest. Or it will be 5% in Mumbai suburban. It will be as per conveyance. Article 25, we will have to see what That's it. Thank you very much. Any questions that you guys have? Yes, please. Can you take the mic, please?
So, in a gift deed, witnesses are required to attest the document. Now, if there is no attestation of gift deed by the witnesses, but during the registration, witnesses have signed at the registrar's office. So, will that be considered as a valid document, or it will be considered as an invalid in that case?
According to the
Those witnesses
Ah.
registration is different. The document itself has to have a witness. That is compulsory. Otherwise, the gift is what?
Okay, so I don't clearly remember the section, but then you cannot cancel the gift deed. So if it is invalid and we have registered it,
That's
so
okay. It's
we
invalid.
can go for. I mean, because there is no attestation, but the document is registered. Then is there? You can say, I mean, it is invalid. Then I don't know if it is in my title tomorrow. If I say that it is registered, it has passed on. And
No, it's compulsory. You have to have. I had a case where a brother, to avoid some attachment of the property, gifted it, or there were some divorce proceedings between him and his wife, and he transferred because he was scared that the property will be. He transferred the property to his brother, but there was only one witness. And that was held not to be a valid gift.
so in that case,
It's compulsory. There are many judgments on this. Look it up. There are many judgments.
there's a section which clearly says that it is compulsory attested. So just as she had a case, we had a case where the father had gifted to the daughter. It was not attested. And it was attested only by one witness. And at the registrar's office, the registrar was one witness and there was another witness for the registration process. Invalid.
and so
There are many judgments. I don't know if you all are familiar with SCC on that. So look up these judgments. Very interesting judgments on this point.
one more question. Now, in presence of there is written witness one, witness two. So below the donors, there is space for signing of two witnesses, as I've seen it generally also. But so is it that supposedly below the signature clause of the donor, one witness signs and then there is signature clause of the donee and the other witness signs there. So will it be considered as attested by both the?
No, that is exactly what happened with my case.
Okay, so
You have to have
two
witnesses
witnesses
for the
for
donor.
donor and two witnesses for donee.
Not two witnesses for donee is okay. Donee has to accept.
Okay.
But two witnesses for the donors compulsory, you will not be able to get out of that if there is no witness.
Yeah.
In will, the witnesses need not know the content, but the person who is signing it, the dictator should be signing it, that should be the thing. So similarly in gift deed, is it such that we need not know the content, the witness?
Yes.
And there is now there are judgments to say that if the father or the mother gift the flat to the children and the children don't look after or misbehave with the parents, they can ask for cancellation of the gift. So if somebody gives you, please make sure that
You look after
and
them.
take care of your parents. So there are many judgments on this.
So
So
you
you have
see
these judgments, it's
papers.
very interesting judgments, and if you put a little bit in your paper, you get a few additional marks on this sort of thing.
Any more questions?
So in this divorce case, it was very interesting. The wife was not educated. She had just done her I think graduation and then got married. And because of this divorce and all this, she did her law on your WhatsApp, sometimes you get a lot of judgments, recent judgments which are given by various courts and all. Do look at that because they are very, very interesting. And if it relates to your papers, you can always mention something in your paper. You don't need to know the name of the judgment, you don't need to know the citation, but you can always put the ratio. So the examiner feels that yours is not a run-of-the-mill paper. It's a paper that you are aware of things that are happening. So make sure you write a little bit, wherever required. Make sure you write a little bit.
And one thing that you can do is, as she said, there are so many WhatsApp groups and people send up to your car and page and all that. You could make a book subject-wise, via exercise book which has all the ABCD. And subject-wise, you could just start noting the judgments, saying in this matter, this was held, this matter. You're not going to study. It will be easy to locate. You're supposed to know judgment 6 months prior to the exam. Yeah, sure.
Whether in the examination you have to quote the recent judgments or old judgments also.
What is precedent is precedent. It's good law, it's good law.
Because somewhere in the law society document I read it should be within 3 years or something like that.
So therefore we are saying that, see, when you read from commentary books, you will find, like in companies, you will find legal industries. Okay? It is law which is followed for years. Keshananda Gandhi. Now, there may be many judgments which we have followed that. So, if you cite the basic, also that is good. And if you find later law which supports it or something new point which is developed or a differentiation or distinguishing of an earlier judgment, then of course you should know.
And about these precedents, whether during examination you have to write for these 6 pages, 7 pages, right? Suppose if the question is a draft.
So if a gift deed is given, yes, then he will give you 20 marks for it, no? So for a deed of covenant, I don't know how much is now in your papers. 5 marks, 10 marks comes for one covenant or something. So if you know it, those are absolutely things in your pocket. And if he's giving you something as long as that,
I
he
may
will
know
show
it,
you.
whether
No.
you have the time to reproduce that thing.
So what
those
the
errors.
examiner in charge normally does is, if he feels that the paper is very lengthy, he gives you additional time. It's not a given, but sometimes he will say 10 minutes extra, 15 minutes extra, maybe 20 minutes extra. The examiner in charge decides at the time when he is handing over papers, he gives you according to him what is reasonable time. And yes, you need to write a lot and sometimes papers are lengthy, but if a whole deed of gift is asked, then the examiner will take care of it by giving you some other things which are much shorter. And he'll give you many more marks for a whole document. He tells you to do a deed of conveyance, he's going to give you substantial marks for it. So it's unlikely that you will get a full deed of conveyance, but I have not recently seen the papers, so I don't know. But when I have seen them some time ago, they are covenants. So there are 20, 30 covenants that if you learn across the conveyancing paper. So you will have covenants in partnership, you will have covenants in conveyance, you will have covenants in rectification deeds, in confirmation deeds, whatever. There is an entire list of things that can be asked. They may ask a whole thing, they may ask you to draft a will. It's not very long. You could make a simple will. 2-3 pages and you are done. You don't have to complicate everything. Any other? Now you're all going to pass the conveyancing paper. Sure.
But in the will, is now gift deed has been made by the estate, and he wants to, and it should the gift deed should be annexed in the will, or is it just you have to mention it that there is this property has been gifted to so and so person to a gift deed, so and so date and registered. So how is it? So along with the will, the gift deed should be annexed.
No, so what So there is no reference required to be made with the gifting this property done. But if you want to gift it to one child, you want to kind of now not give that child anything else, you may want to mention that I have in my lifetime already gifted this property by instrument, registered instrument, bearing registration number, so and so, etc., etc. And you may mention it just to kind of explain as to why there is nothing more happening.
Ma'am, I just wanted to ask you, are there any books that will help us to get to know the crafts much better? Or something
See,
that
if you
can
are
help us
working in a
to-
solicitor's firm and that firm is doing conveyancing, it may be better to pick up drafts which are with that firm because you may be familiar with it. Otherwise, there is Tijoriwala which is there, and I believe Sandeep is editing, Sandeep Madala I think is re-editing it or whatever. Then there's of course Vivek which is in multiple volumes. So collect proceedings whilst you are working. Start collecting proceedings, right? Even judgments. Start making a note subject-wise, or start taking the ARs from the High Court Library home. You need to do only Bombay and Supreme Court. Look at the nominal index, not the name index, the subject index. See, arbitration, what are the judgments reported in this year? Write them down. There may be something which may be different. Thank you.